All right. Good morning. Good morning. Welcome to our discussion on a crazy case, a crazy lawsuit that went to trial last month. We just got the final judgment a couple of days ago. So we're going to go through it together. I'm Cristen Martinez. I'm a real estate attorney. I have a passion for educating the real estate community, helping you guys avoid lawsuits and litigation, which is what we're talking about today. So I thought here on my YouTube channel, we could learn things. I could give you best practices through real life case studies and case examples. I have a big following on TikTok. I have a lot of educational content over on TikTok, but I can't dive in as deep as I want to and as I think would benefit you guys into the different cases. Literally every time I post a TikTok about an actual lawsuit I'm working on, the views, the comments, they blow up, they go crazy. That seems to be the content that you guys want to hear. So let me know what questions you have. I'm doing this as a live stream so we can have a conversation together, so we can talk about things together, so I can answer your questions, so you can tell me if I'm not explaining things in as clearly as I think I am, all of those good fun things. But we're going to go ahead and dive in. So I'm going to give you a brief summary, and then we're going to pull up the actual court documents and we're going to go through the case, and I'm going to point some things out to you. I'm going to give you my position. We can talk about it. We can disagree. We can have a fun conversation and kind of nerd out on real estate law. So this started out as a landlord-tenant dispute. This was an eviction case, and we filed the initial complaint for eviction and for damages. And the damages claim started as a simple non-payment of rent, and then it kind of graduated. Spoiler, the tenant eventually moved out during the pendency of the lawsuit, and my client noticed damages in the property. So that claim was amended to include physical damages to the property. There was a flurry of motions and responses and motions for sanctions that my opponent ended up filing, none of which were granted. Don't be alarmed. But we're going to go through all of that. And then, like I said, we had the final trial down in Broward County last month in July. 30 days was a long time to wait, but we had to wait 30 days for a final judgment from the court, which we did get a few days ago. And we're going to be going through that as well. I may need to do this in 2 parts or 3. So we will see. It depends on how long I talk and how interested you guys are in the content. So have I shared my screen? I have not. All right. So the first document that we're going to take a look at is the complaint. And hopefully you all can see that there. And so the complaint is the first document that's filed in a lawsuit. This is what actually initiates the lawsuit. In small claims court, it can be called a statement of claim. In county court or circuit court, it's called a complaint. And we are here in county court. So this is our complaint for eviction. We start out with a general statement of who's suing who. So the Miguel Tamarit Revocable Trust is suing the defendants, Stacy Hood and Todd Cohen. All complaints are required to contain a statement of the parties and the jurisdiction, just to make sure we know who we're suing. And we filed the lawsuit in the correct court and in the correct location or venue. And so we're not going to go through this in detail, but that's what this is alleging. And the general allegations is where the meat of all of this starts. And so this is where the facts are alleged. And these are the facts that ultimately my client, as the plaintiff, is going to have to prove at trial in order to prevail on the claims we're making. So here we allege that the plaintiff is the fee simple owner of the real property that is the subject of this action. We have to allege that. If we can't prove he's the owner, we lose. So that's the first critical element that we have to allege. The plaintiffs entered into a written lease agreement with the defendants on January 4th of 2021. This lease agreement is very important. This lease agreement is very poorly drafted. We're going to learn a lot of lessons from it. And we are going to review the actual lease agreement here in a minute because it is attached to the lawsuit. The written lease agreement expired on February 4th, 2022. Defendant Hood continued to reside in the property as a month-to-month tenant after expiration of the lease from February 4th, 2022 to the date of filing this action. She's currently residing in the property. Unknown tenants and occupants are in violation of the lease, and the monthly rent amount due is $2,500. So you notice we only allege that defendant Hood is currently residing in the premises. There was a second defendant named, that is Mr. Todd Cohen. He was a party to the lease. However, we do not believe he ever moved into the property. We don't believe he ever lived there. My client's position and belief is that the only reason Mr. Cohen was added to the lease was because Ms. Hood could not qualify from a financial and a credit standpoint with the HOA to be accepted as a tenant in that community. Red flag number one, I know. The allegations continue that the defendants are currently delinquent in rent payments in the total amount of $15,000. Yes, that's a lot. Landlord has complied with all of its obligations. On July 5th of 2022, the plaintiffs delivered a 3-day and a 15-day notice. That is also attached. That's also going to become very important to this case. As of the date of this complaint, defendants have failed to pay all amounts due and have failed to surrender possession of the premises. And then we have some kind of standard allegations here. Plaintiffs have hired my law firm. They've agreed to pay me. All conditions precedent have been performed, and plaintiffs are entitled to recover their attorney's fees and costs if they are the prevailing party here. So those are the facts of the case. Every complaint, and they may call it, statement of facts. We called it general allegations. That may differ, but those are the facts of the case. We're now going to get into each individual claim, and these are listed out in counts. So you can see count 1 here is eviction based on non-payment of rent. Each one of these claims is what is ultimately going to be heard by the court at trial. So the way these are laid out and how they're pled is extremely important. Very, very, very early on, this is literally the first step in the lawsuit. So count 1 is for eviction. We're going to be a bit repetitive here. So we allege that the defendants were served with the 3-day and 15-day notice on July 5th. Let's talk about that. So why was the notice both a 3-day notice and a 15-day notice kind of rolled up in one? So number one, if you remember from the general allegations, the tenant was delinquent in rent payment. And under Florida law, when a tenant doesn't pay rent, the landlord has to give a 3-day notice. And within those 3 days, the tenant either has to pay the unpaid rent or they have to move out. If they don't do one of those two things within that 3-day period, the landlord can then sue for eviction. So that's why we included the 3-day notice here, because the tenant was in default of her rent payments. The 15-day notice was also served here because, if you remember again from the general allegations, the lease expired February 4th of 2022. The tenant didn't move out when the lease expired, and so by law, she became a month-to-month tenant. And in order to terminate a month-to-month tenancy, the law requires a 15-day notice. We're in August of 2023. That was just amended, FYI. So that time period is now 30 days. But at the time that this lawsuit was filed, the required notice to terminate a month-to-month tenancy was 15 days. So when both causes of action or both sets of facts are there, the non-payment of rent and the holdover tenant, the tenant that stays beyond the lease term, my office's policy is always to send both types of notices. Therefore, if we happen to lose on the non-payment of rent, I paid the rent, all the checks are sitting in the landlord's mailbox, he just didn't check his mail, something silly like that, we still get our eviction because we can fall back on the 15-day notice and vice versa. So that was the reason for kind of a dual notice in this case. We go through, as of the date of this complaint, defendants hasn't paid her rent, they're month-to-month tenants, and therefore the plaintiff is entitled to immediate possession. We focused here on the month-to-month tenancy portion of the default or that basis for eviction. And the reason we do that is because with non-payment of rent, that basis gives rise to all sorts of potential defenses. Well, my AC broke and the landlord never paid it or never fixed it. And so I shouldn't have to pay rent because I was forced to live in Florida in the heat of summer with no AC. And that's just one of hundreds of examples tenants can come up with. With the month-to-month tenancy, there's far less defenses that are available to dispute the facts we have to prove. Number one, that the lease ended, and number two, that the tenant didn't move out. It doesn't matter whether there was a repair that wasn't made. It doesn't matter whether the landlord breached the lease agreement in some way. If the lease ended and the tenant didn't move out, landlord is entitled to evict, assuming that proper notice is given. And so that's why we focus here on that basis versus the non-payment of rent basis. So that is count number one. Every single count has to have what we call a wherefore clause here, which is the specific relief that the plaintiff is asking the court for. So here, plaintiff respectfully requests, we always do it respectfully when we're asking the court to do something, a judgment for possession with a writ of possession to issue forthwith. So that is granting us the eviction, issuing a final judgment saying the tenant has to move out, landlord plaintiff has full possession. And if the tenant doesn't move out, there's going to be a writ of possession that the sheriff can serve to force the tenant out. Together with an award of attorney's fees and costs, that is required to be pled. Attorney's fees and costs are required to be included in the original complaint, or you waive that right. Big, huge, fat mistake to forget to claim attorney's fees in your complaint, because if you don't do it in the complaint, you waive it. And we request that the court advance this cause on the calendar pursuant to summary procedure. What that means is that by law, eviction cases are deemed time sensitive, more so than other types of lawsuits. And so they are entitled to what we call summary procedure, which is basically just a fast track. The deadlines are a lot shorter. The judge is required to advance the cause on their calendar. Give us sooner hearing times than you're making available to all your other cases. We should get priority. And finally, we request such other and further relief as this court deems just and proper under the circumstances. We always include kind of a catch-all in case we get to trial, which is usually months, sometimes a year or more down the road, and something transpires and we're like, ooh, we should have requested this. We kind of have a catch-all there so that we can request additional relief that we may not have specifically requested in the complaint itself. So that is claim number one. This is what an eviction complaint looks like. This is what you are required to allege. If you are a landlord and you're trying to evict your tenant, remember that you do have to attach both the lease agreement, if one exists, and the notice that was sent, whether that be a 3-day, a 7-day, a 15-day, or a combination of one of those. All right, moving on to count two. And let me see if I don't know how to see my comments. Bear with me here because this is my first time doing this and I'm not sure how to see my comments, and I want to make sure that I can see them and respond to questions if you have them. I don't see any. So it says 2 comments, and then when I click video comments, it doesn't show me anything. So I'm guessing that means we have no comments. Let's see. See comments. All right. Well, I don't see comments, so I deeply apologize if you're asking questions or you have comments and I'm not responding or answering them. I will try to keep an eye on this, but I'm not sure why it's not showing me the comments here. Let me refresh this. All right. Well, we're going to move on. I will go back and take a look at the comments and answer them in writing if there are, in fact, comments there that I just can't see because I am not technologically savvy. So I'm actually impressed with myself that I've been able to share screens and do this stream to begin with. So, all right, let's move on to count 2, which is our damages count. So in the eviction count, All we're asking for is possession of the property and attorney's fees, no actual damages. So if we want damages, we have to plead that as a separate cause of action. So that's what this count 2 is. We recite what we've stated in our general allegations. Plaintiff owns the property. There was a lease and then a subsequent month-to-month tenancy whereby the defendant was required to pay monthly rent in the amount of $2,500. Defendant failed to pay the monthly rent as it became due starting March 1st of 2022. When was this lawsuit filed? So this lawsuit was filed August the 8th of 2022. Plaintiffs have been damaged as a result. Seems obvious, but damages have to be specifically alleged in the complaint in order for it to be valid. As of the date of this complaint, defendants owe the total amount of $15,000 to the plaintiffs, and plaintiffs are entitled to their unpaid rent, late fees, interest, and attorney's fees and costs. We have a very similar wherefore clause where, excuse me, we are demanding judgment here, folks. We are not respectfully requesting it as we should have. We are demanding it. So we are demanding judgment this time against both defendants for damages, pre and post judgment interest, and attorney's fees and costs. Let's take a look at the exhibits. So the first exhibit we see here is the lease agreement. This is required to be attached to any claim that is based on the lease, any contract. So if you're filing a lawsuit based on a contract, you have to attach it as an exhibit. So this lease, as we will see, is a bit of a mess. So first we have this contract to lease. And these documents were all done by the respective real estate agents for the parties. I don't typically recommend real estate agents prepare lease agreements. There's too much that goes into them. Yes, there are standard form lease agreements here in Florida that realtors often use, and legally that they are allowed to use. So I'm not saying the agents here did anything wrong. Legally, I'm not saying they are participating in the unlicensed practice of law. I am saying these documents are a hot mess. So the first document we have is a contract to lease. And this is essentially an agreement to enter into a lease agreement based on these terms. So we have the parties identified, we have the property address, we have the term of the lease, we have the rent amount, we have the money that's due up front. So that's going to be first month's rent and a security deposit. We have pets identified, and then we have some other basic terms of the lease agreement. We're not going to focus on this document because this document is not enforceable. It's an agreement to agree. And we do, in fact, have a lease agreement that was signed subsequent to this document. So we attached it here to make the court aware of all the facts, all the documentation. We're not trying to hide anything from the court, but this document's not enforceable, so we are not going to focus on it much. All right, we then have our non-lawyer disclosure. So we have these real estate agents that are assisting with the lease. They're not lawyers, and that's the disclosure that was filled out. Here is the standard residential lease form that is available for real estate agents to use here in the state of Florida. I don't like it. I don't typically recommend it. Is it better than your clients going to get something off of Google? Absolutely, yes. So if your client's telling you, I'm not hiring a lawyer, I don't care what you say, you either give me this lease or I'm going to go find one, give them this lease. All right, let's take a look at it. So we have the parties identified. The landlord is the Miguel Tamarit Revocable Trust. Tenants are the defendants in the action, Stacy Hood and Todd Cohen. We have the lease term, February 5th, 2021 to February 4th, 2022. So that's a 1-year term. The rent payments, $2,500 per month, which we did go through. Let me just check again for comments. I'm not sure if this is working yet, but I don't want to miss your questions if you have them. So let's see. 6 days, 2 hours ago. What's this? I'm seeing some more content. So let me see if I have comments here. I still don't see it. All right. I'm sorry, guys. I'm going to figure this out for next time. Oh, I see. We do have a comment and I can see it. All right. I can't believe the judge partially sided with the plaintiff. Yes. So spoiler alert here. The final judgment was basically like, plaintiff, you win a little bit, you lose a little bit. Defendant, you win a little bit, you lose a little bit. So we're going to go through all of that and the implications of that. But yay, I can see the comments. All right. Sorry for that sidebar. Back to the lease agreement. So we have the $2,500 a month, and then we have, let's see where all right, paragraph 5, money due prior to occupancy, $7,500. That's first month's rent, which is $2,500, and the security deposit, which is $5,000. That security deposit is being fought over in this case. There was an amended complaint filed later in the case. The tenant did end up moving out. When she moved out, my client did an inspection, found damages, and so we amended the complaint to add a claim for the security deposit. The counterclaim was also amended by the defendants, adding a claim for the security deposit because she felt she was entitled to the entirety of it. All right, so we are going to skip down to the important parts here. So early termination addendum, this did not come into play, so this is not relevant really to the facts of our case. The Chapter 83 of the Florida statutes, you may not know this. This is required to be attached to all leases. So kudos to the real estate agents for knowing that and attaching it here. We are going to skip through that for the time being, though. And we are going to take a look at this addendum to contract because this is key in the case and in the judge's ruling of the case. Let's see here. Please share your phone number to call your office. I will do that now before I forget. There you go. All right. Thanks, guys. Let me know what questions you have in the comments, and I will do my best to answer those for you. All right, so the addendum to contract. The first part of the addendum, and this is a standard form addendum. I believe this addendum is meant for the standard real estate purchase and sale agreement, but it is what it is. This, I would say, does constitute technically the unlicensed practice of law. Real estate agents, quick sidebar here. Real estate agents are allowed to do a little bit more than members of the general public, but not quite as much, not nearly as much as a licensed attorney. So what real estate agents are allowed to do when it comes to drafting contracts, documents, lease agreements, is they are allowed to take a standard form agreement that has been approved by the Florida Supreme Court. So that's going to be your Florida Realtors documents, like this lease agreement we just reviewed. That's going to be your FAR contracts, your CRISP contracts. And they are allowed to fill in the blanks of the standard form contract based upon their conversation with their client. What they are not allowed to do is they are not allowed to alter the pre-printed standard language of the contracts. They are also not permitted to draft their own contractual provisions, which is what we have here. This is a blank addendum. I wish it didn't exist because legally realtors aren't allowed to use it. They can use it if they have an attorney draft the language and they can plop that language into the blank standard form addendum. Usually they don't do that. This kind of freehanding, let me just type in this language that's going to bind the parties, that is the practice of law. And that is the unauthorized practice of law by a real estate agent. So be careful with that. I know it happens all day, every day. I get it. But be careful. You don't want to put yourself in a position where somebody has a potential claim against you for that. All right, so we're going to focus on the first sentence here, which states, landlord and tenant agree to renew the lease at the current rate of $2,500 per month for second year, February 4th, 2022 to February 3rd, 2023. So what we have here is a one-year lease agreement. Also keep in mind that real estate agents are not allowed to draft leases for more than 1 year in length. Does drafting a lease agreement for 1 year and then drafting an addendum for an additional year constitute a lease agreement longer than 1 year in length? I say yes. I don't know if that issue's been litigated. I say yes. So don't do that. But this is the key language here. So, and we'll get into it, but the defendant's position is I was entitled to a new 1 year lease from February 4th of 22 to February 3rd of 23. The plaintiff didn't give me a new lease for that 1 year. And so the plaintiff is in breach of the lease and I should be paid damages. That is, in summary, the crux of their argument. And this is where that argument comes from. All right, next exhibit is our notice. This is our 3 and 15-day notice. So in here, we have demanded the rent. This notice, as you can see, is dated June 27th. The lawsuit was filed. When was the lawsuit filed? Let me go back and see, because now I forget. Oops. All right, so lawsuit was filed August of 2022. Let's go back to page 29. All right, so a little over a month later. And why I looked at that is because one of opposing counsel's arguments was, but Your Honor, in the notice, they request $10,000 in rent. But in the lawsuit, they request $15,000 in rent. That's unethical. They're not being candid with the court. How in the world can they request more in the lawsuit than they did in their notice? Well, sir, our notice was dated June 27th. There was another rent payment of $2,500 due July 1st. And then there was another payment of $2,500 due August 1st. $2,500 plus $2,500 equals $5,000, which is how we get from $10,000 on June 27th to $5,000 on August whatever, when the lawsuit was filed. These are the arguments I have to make sometimes to the court. And I'm like, how do I even make this argument? Like, can I just hand the court the documents and say, like, no comment needed, judge, just take a look at it? You always want to strike that balance of, advocating for your client aggressively, informing the court of all of the facts the court needs in order to be able to make a decision, but also not offending the judge by saying $2,500 plus $2,500 equals $5,000. Total sidebar, but this is the joint 3 and 5 day notice. This is also part of the basis of our claim, and so we included this as an exhibit as well. And that is our last exhibit. So that is the complaint. We have been going, let's see, for 24 minutes. I'm going to go ahead and go through the responsive documents that opposing counsel filed. Probably going to take us another 24 minutes. And then, not to kind of tease you and then not deliver on what I said I was going to do, but we're going to do the final judgment in part 2, because there's just so much that transpired between the initial pleadings, which I think are important to go through, in the final trial and the evidence at trial and the final judgment itself. So we're going to do that in a part 2. I will schedule it. I'll spread the word. I'll let you guys know. But let's go ahead and take a look at the responsive pleading that we got, which you guys can't see that. So I am going to stop share and reshare. All right. Share screen. And we should be rocking and rolling on this. All right. So this is the responsive pleading that I got. And this includes many things. And we're going to go through them all. So this includes a motion to dismiss, an answer and affirmative defenses, a counterclaim, a motion for judgment on the pleadings, a motion to determine rent, and a 57-105 motion for sanctions. I mean, wow. Imagine my face when I opened up my email and viewed this document. Imagine. All right, we are going to tackle this monster of a pleading with all of these wonderful claims and motions in it. Is this typical, you might ask? No one's asked that in the comments, but you're probably wondering, is stuffing all of these motions and things into one pleading, the first responsive pleading to the complaint, typical? Absolutely not. And I would venture to say, I don't think I've seen anything like this in my 14 years of practice. But hey, this was filed September 9th of 2022. So as of September of last year, this was yet another first in my career. So defendant Stacy Hood, by and through her undersigned counsel, files this, her motion to dismiss, answer and affirmative defenses, counterclaim, motion for judgment on the pleadings, motion to determine rent, and Florida statute section 57.105, motion for sanctions in response to plaintiff's complaint in as grounds, states as follows. Let's start with the motion to dismiss. And typically all motions to dismiss start with the legal standard that the court is required to follow. Does the court already know this legal standard? Yes, but it is something that attorneys just do. In the off chance you have a judge that doesn't know the legal standard, but you also want to couch the legal standard in a way that benefits your position. So the legal standard is what it is. There's certain language that helps your position. There's certain language that may be more favorable to your opponent's position. So you want to state the standard in a way that highlights or assists you in arguing your position. So to rule on a motion to dismiss, a court is limited in review to the four corners of the complaint, including attachments incorporated in it, and all well-pleaded allegations are taken as true. So this is very important. When reviewing or when deciding on a motion to dismiss, the only thing the court can look at is the complaint itself and anything attached to it. That's what we call the four corners of the complaint. The court cannot rely on or consider documents outside of the complaint, testimony, facts, affidavits, anything that is not contained in the complaint itself, which is why it's important to do an amazing job drafting that complaint. Because if it's not drafted properly and you didn't include something in it you should have, the court can't consider those facts. All right, a motion to dismiss for failure to state a cause of action may be raised at any time under the Florida Rules of Civil Procedure and may be asserted in a motion to dismiss. Agreed. In ruling on a motion to dismiss, the court must confine itself to the allegations contained within the four corners of the pleading. Thank you for restating that well-known standard of law. The allegations must be accepted as true and considered in the light most favorable to the non-moving party. So what this means is, if there's any doubt in the complaint as to whether the claim was properly stated or not, that doubt must be resolved in favor of the non-moving party. The moving party in this case is the defendant. That's the party who filed the motion. The non-moving party is the plaintiff. So any and all doubts have to be resolved in favor of the plaintiff. However, the application of the standard does not mean that the courts will allow inference or speculation to supply essential averments that are lacking. Also don't disagree. And that's part of the standard that is going to benefit his argument. We'll get there. But although courts must liberally construe and accept as true factual allegations in a complaint, as well as reasonable inferences from it, the court need not accept internally inconsistent factual claims, conclusory allegations, unwarranted deductions, or mere legal conclusions made by a party. Also agree with this. So if you state in your complaint, the monthly rent was $3,500 a month, and she only paid me $2,500 a month, but you attach the lease and the lease says monthly rent was $2,500 a month, that complaint's getting dismissed because your own attachment, the lease agreement itself, is contradicting what you say in the complaint. Those facts don't have to be taken as true if contradicted by an exhibit to the complaint or some other allegation in the complaint. And the case law supporting that position is cited here. The Florida Supreme Court has ruled that contradictory and inconsistent statements in a pleading neutralize each other and thus have the deleterious effect that the claimant failed to state a cause of action. You get the gist of the standard. Let's move on to the arguments. Plaintiff's complaint must be dismissed with prejudice. This is some serious stuff, y'all. With prejudice means we're barred from ever refiling this claim. We can't go fix the errors we made in the complaint and refile. We should never have a chance to be able to refile this claim ever again. That's what this attorney's arguing. Plaintiff's complaint must be dismissed with prejudice for his A, deficient notice to terminate a month-to-month tenancy. So they're saying our 15-day notice was defective, and B, a defective 3-day notice. Keep in mind that the eviction count was based on the termination of the month-to-month tenancy, not on the non-payment of rent. So even assuming arguendo, that's a fancy word lawyers like to use for assuming for the purposes of argument that the 3-day notice was defective, it wouldn't matter because we're not suing on the 3-day notice. We're suing on the 15-day notice. But he also thinks our 15-day notice was deficient. So let's take a look at his reasoning and basis for that. All right, plaintiff's complaint for residential eviction and damages must be dismissed with prejudice for his failure to comply with Broward County Ordinance, blah, 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 which states a residential tenancy without a specific duration and in which the rent is payable on a quarterly or monthly basis may be terminated by either the landlord or tenant by giving not less than 60 days written notice prior to the end of the applicable quarterly or monthly period. All right. So what he is saying here is the Florida statutes require a 15-day notice to terminate a month-to-month tenancy. He's arguing that there is a Broward County ordinance, a separate ordinance that extends that required notice period to 60 days. And because we only gave a 15-day notice and not a 60-day notice, our notice is insufficient. Now, his argument's not going to fly, and I'll tell you why. But assuming it did, a dismissal with prejudice is just not going to happen here. The court would say, presumably, he's right. Go give 60-day notice and then refile your eviction. It can be fixed, but this argument would be a wonderful argument. And I'm not going to go through his argument because I don't disagree that if this ordinance applied to the facts of our case, he would be right. 60 days notice would be required, not 15. However, Sir did not check the effective dates of the ordinance before filing this motion because the ordinance did not become effective until after our notice was sent. The ordinance, and it does not apply retroactively. So the ordinance was not in effect when we sent our 15 days notice, meaning it doesn't apply, meaning we default to the Florida statutes, which means 15 days notice is what was required. So do your research, my guy. All right, so that is his argument on our defective 15-day notice. So paragraph B, defective 3-day notice letter. We're not going to go through this. It doesn't matter. I don't agree if it was defective, but even if it was, we didn't sue on it, so it's irrelevant. Okay. All right, so we go on and on about the 3-day notice and the law and this and that, and this is, wow, a very lengthy argument on that. All right, there's his wherefore clause. He's demanding judgment, not respectfully, against the plaintiff and an award of her reasonable attorney's fees and costs for the defense hereof pursuant to the lease and Florida statute sections 83.594 and 83.625 and such other relief as this court may deem just and proper under the circumstances. The court heard this motion, and because within this same document, the lawyer for the defendant also filed an answer in affirmative defenses, which is procedurally improper. You file a motion to dismiss, or you file an answer and affirmative defenses. You don't file both, because if your motion to dismiss has merit and the complaint should be dismissed, you're not required to file an answer on that complaint. So when this motion to dismiss was set for hearing, The judge said, I'm not going to consider it. You already filed an answer and defenses simultaneously with this motion, so it's moot, so denied. So he lost on procedural grounds. He would have also lost on substantive grounds, but do your research, my guy. All right, so let's take a look next at this Florida statute section 5710, should say 105, motion for sanctions. Now, these motions are serious. This is a motion asking that the court to sanction the plaintiff and his attorney for filing a frivolous claim. This is a very high standard, a very high burden. It's not something that's taken lightly. It's not something that should be filed lightly by attorneys. And there were many of these motions filed in this case, which is another first for me in my career. I've never seen a case where more than one, much less like 3 or 4 motions for sanctions were filed in a lawsuit by the same party. These were all denied, so don't be concerned. I was not sanctioned. But this is some serious stuff. So these motions are in fact so serious that the statute, section 57105 of the Florida statutes, provide for what's called a safe harbor notice. And what attorneys are required to do, if they think a claim is frivolous and they want to file this very serious motion for sanctions, the statute requires them to send a letter to the attorney who filed the frivolous claim saying, hey, I reviewed your claim. I think it's frivolous. Here's why I think it's frivolous. Here's the law that says your claim doesn't have legal merit. I intend to file a motion for sanctions. I'm giving you 21 days to review your claim, to review my law that I'm providing you, why I think it's frivolous, and to withdraw your claim so that you can avoid having a motion for sanctions filed against you. Well, guess who didn't file a safe harbor letter? So he's filing a motion for sanctions saying that our claims are frivolous without complying with the statute, which means that his motion for sanctions is in fact frivolous and sanctionable. Did I file a counter motion for sanctions? No. Judges typically don't like these unless they do have merit and they're used for what they're for. And the claims are frivolous. They're an abuse of process. They're a waste of judicial resources. That's not what we have here, folks. But he did not, this was the initial response to the complaint. No prior communication and certainly no safe harbor letter as required by the statutes. This motion was also denied very quickly by the court. Let's see what he says. So defendant Stacey Hood respectfully requests this court now find and hold that plaintiff and his counsel of record, Martinez Law PA, knew or should have known that plaintiff's complaint is not and was not supported by the material facts necessary to establish the alleged claims, specifically deficient notice to terminate a month-to-month tenancy, a defective 3-day notice, both when initially presented to the court and at present, and that the claims are not supported by the application of existing or then existing law to the material facts of this case, and that defendant is therefore entitled to recover reasonable attorney's fees and costs incurred in obtaining an order on this motion. I mean, this is his whole motion. He doesn't say, he does address the safe harbor. Due to the statutory time restrictions on providing a response to the residential eviction complaint, defendant was unable to this motion at least 21 days prior to filing it with the court pursuant to the statute, but will withdraw said motion if plaintiff dismisses his complaint with prejudice prior to any hearing on this motion. That's not the way it works, my guy. You had 21 days to send the required notice prior to filing this. You're not required to file a motion for sanctions within the time period that you're required to respond to the complaint. You file your response to the complaint, and then after the 21 days passes, then you file your motion for sanctions. So he was aware of the requirement. He decided to ignore it, and this was his reason for ignoring it. Again, this didn't fly, and this was also denied. All right. Now on to his answer. So the pleadings in a case consist of the complaint, an answer to that complaint, and then if there is a counterclaim, the counterclaim, and an answer to the counterclaim. So every complaint has to have an answer. Every claim made in the case has to have a formal response. And this is the formal response to the complaint. In an answer, a defendant is required to go paragraph by paragraph, as you can see here, and either admit or deny the allegations being made in the corresponding paragraph in the complaint. So they'd review the allegations we made in paragraph 1 of the complaint, and then in paragraph 1 of their answer, they're going to say they admit it or they deny it. That's what we see all throughout this answer here. The defendant does state that they are without knowledge to admit or deny. That's also an acceptable answer. For example, paragraph 5, I believe, is plaintiff has hired an attorney and is required to pay them a reasonable fee. Defendant can assume plaintiff hired an attorney because an attorney filed the complaint. Defendant. Defendant can assume that the plaintiff has to pay their attorney. It could be pro bono. They don't know. So they don't have sufficient knowledge to say, yes, this is true, or no, this is not true. So they go through each and every paragraph of the complaint and admit or deny. Defendants denying every single thing is very common, very typical. That's what we do. And then the second part of an answer is affirmative defenses. So at trial, the plaintiff has to prove their claims. So we have to prove both count 1 and count 2 of our complaint. The defendant has to prove each and every affirmative defense that they have alleged in the action. And this is where those are found. All right, so paragraph 36 starts, as and for her first affirmative defense, defendant would state that defendant's lease term renewed on February 4th, 2022 for a term of 12 months at the rate of $2,500 per month. Plaintiff's own Exhibit A, addendum to contract, shows this renewal agreed to and signed by both plaintiff and defendant. Plaintiff is stopped from bringing an action for eviction on a month-to-month tenancy based upon plaintiff's own exhibit to his complaint. Further, defendant sent a communication via email to plaintiff dated November 22nd, 2021, which informed plaintiff that due to his failure to resubmit a new lease to the Management Association to avoid having her fobs and access to the gate turned off, she will be placing all future rent payments into an escrow account, which will be paid to plaintiff upon his execution in submission to the management company of her new lease agreement pursuant to the terms of the addendum. A tenant is not allowed to unilaterally decide, I'm not going to pay you, landlord, anymore because I disagree with what you're doing. I'm just going to put this money over here in a separate account. And if a court tells me I have to pay it to you, I'm going to pay it to you. That's not how this works. It's not allowed. It's not permitted by the law. So while that might seem reasonable, okay, well, there's a dispute. So we're still going to pay the money. We're not going to keep the money. We're going to put the money aside so it's protected until we resolve this dispute. But the landlord is still having to pay their mortgage and the property taxes and the insurance and the HOA fees, which were significant in this case, without the benefit of that rent money. These things have to be determined by a judge. A defendant or a tenant cannot unilaterally decide that this is just what they're going to do. All right. Finally, defendant served plaintiff with a 7-day notice dated March 8th, 2022, pursuant to Florida Statute Section 83.60B, which stated, defendant intends to withhold rent in the amount of $833.33 per month and to deposit the remaining $1,666.67 in a separate escrowed account unless and until you provide a signed lease renewal with the current lease terms within 7 days after delivery of this notice. So now what the tenant is attempting to do is say, you didn't sign a new lease. You were supposed to. As a result, I now cannot access the community with my key fob. I can't go through the resident gate. I also cannot access the amenities of the community because the HOA won't let me because I can't produce a current lease. So I'm going to withhold 1/3 of the rent. I'm going to pay you the 2/3. I'm going to withhold 1/3 of the rent. Well, the tenant didn't actually do this. She just withheld all the rent. She paid some of it into an escrow account, others she didn't. But she didn't disperse the 1666.67 that she said she would to my client. So that's a problem. But this is the crux of what was argued at trial. So our argument is the defendant didn't pay her rent. She failed to pay her rent prior to the end of the first year of that lease, meaning at the time when the parties were required to sign a second year, the defendant was already in breach of the lease. Therefore, my position is the plaintiff is relieved of his obligations to continue to perform under the lease. Florida law says that in a contract, when one party's in breach, the other party can stop performing. That's our position. You're in breach, therefore, there's no way in heck we are going to sign a new lease with you because you already owe us rent. In fact, my client was more reasonable than I probably would have been and said, hey, pay the 3 months in rent that you're behind, and then I'll sign a new lease with you. No problem. She didn't do that. And then the defendant's position is, no, landlord, you're in breach because you signed off that you would provide a new lease. You didn't do that. And now I've suffered damages as a result. And those damages are essentially $833 per month. That's what I value the lack of being able to go through the resident line at the gate and being able to use the amenities. All right, we have additional affirmative defenses for the deficient 15 and 3-day notices, which we've already reviewed. Fourth affirmative defense would state that plaintiff's claims are barred pursuant to Florida statute section 83.60b, basically stating that a material noncompliance with the statute is a complete defense for an action for possession. So the violation that they are alleging here is that the rent payment that was due included use of the amenities. The tenant couldn't use the amenities, and so by suing or attempting to collect full rent, landlord is in breach. And as for her fifth affirmative defense, defendant asserts that the plaintiff is barred by his own unclean hands in refusing to provide defendant with a new lease. Unclean hands is an equitable defense. It is only available in equitable causes of action. An eviction is a cause of action in equity. However, in order to show unclean hands, the courts relate it to conduct that rises to the level of fraud. So they would essentially have to show that I signed a 1-year lease with you, me, the landlord, I signed a 1-year lease with you, and I signed this addendum saying that I was willing, that I agreed to sign a second year. But when I signed that initial lease with you, I knew I was never going to give you a second lease. I was just tricking you into signing the first lease with you by lying and saying I was going to give you a second year. But I knew all along I wasn't going to give you that second year. That didn't happen. The facts don't support it. This defense was not successful. And then finally, we have a motion for judgment on the pleadings, which is also interesting to file in conjunction with an answer and affirmative defenses. The standard here, a motion for judgment on the pleading should only be granted if the moving party is entitled to a judgment as a matter of law. All right. Nope, this is very short. Plaintiff's own Exhibit A proves that defendant had a valid and enforceable lease. No, it doesn't. It proves that there was an addendum signed that says we would sign a new lease, but there was no valid and enforceable lease signed. Alrighty then. Therefore, defendant must be granted a judgment on the pleadings based on plaintiff's complaint. And that's the whole motion. I'm sure you know what happened with this motion. It was also denied. All right, let's see what we have. Unless they have a case with the court and they're depositing the money into the court's registry. Correct. Whoops, I missed your first comment. So once the tenant fails to pay, they breach the lease. Furthermore, they can't take it upon themselves to deduct money for rent unless they have a case with the court and they're depositing the money into the court registry. You are absolutely 100% correct. So once an eviction action is filed, the tenant is required to place all of the disputed rent, the amount of rent the landlord says is owed, into the registry of the court. And if they don't, they get a default judgment against them. So the tenant did start making rent payments into the registry of the court once we filed. prior to us filing, she sent this email to my client saying she would just put it in escrow. She never did. But even if she did do that, she wasn't permitted to do that. All right, let's take a look at the counterclaim. The judgment on the pleadings was denied, as I'm sure you could have guessed. All right, counterclaim. We've gone through a lot of the facts in their answer, so let's take a look at the exact claim. So counterclaim count 1, breach of lease. Pursuant to the addendum, Tamrit and Hood agreed to renew the lease at the current rate of $2,500 per month from February 4th, 2022 to February 3rd, 2023. I don't know why I was saying it like that. That was weird. Tamrit has failed to comply with the lease by failing to provide a renewed written lease for that time period. Tamrit's in breach of the lease. Due to his breach, Hood has been damaged. Therefore, we demand judgment. Standard, typical breach of contract claim. Don't have any problem with that. Counterclaim count number 2, specific performance. Tamrit as landlord and Hood as tenant entered into the lease agreement pursuant to the addendum. Tamrit and Hood agreed to renew the lease for an additional year. Tamrit has failed to comply with the lease by failing to provide a renewed written lease for an additional year. Stacy Hood demands judgment. No problem with that either. Motion to determine rent due to the discrepancy in the amount of rent due and owing pursuant to defendant's 7-day notice of withholding rent dated March 8th. Defendant respectfully requests an evidentiary hearing to determine the amount of rent to be deposited into the court registry. That did not happen. However, the tenant did deposit the rent into the court registry, so no issue with that. And that, my friends, then we get into the exhibits. So that, my friends, is the motion to dismiss, the answer and affirmative defenses, the counterclaim, the motion for sanctions, and the motion for judgment on the pleadings. Lots going on there. The motions were all denied. The answer and defenses were adjudicated at the final trial, which again happened next month. I will be doing a part 2. I'll be doing another live stream with information on the trial, the evidence that was presented, the legal arguments that were made, and then we are going to go through together the final judgment. This live stream went an hour. I thought it might. But I also thought I would get through the whole trial and the final judgment within the hour, which I didn't. So apologies. But thank you for attending. Thank you for hanging out with me. Let me know what thoughts, comments, questions you have in the chat. Be happy to go through those. If you wouldn't mind, please like, subscribe, get notifications, whatever you can do to support my channel here on YouTube. I would greatly appreciate it. It is a brand new channel. I'm trying to grow. I'm trying to further my reach with being able to educate investors, homeowners, home buyers, home sellers, real estate agents, real estate professionals throughout the state of Florida. So you all can avoid lawsuits that we've seen, like the one we've seen today. So there's going to be a lot more of this type of content. If you have content suggestions, reach out to me. Let me know those. Email me, contact me on YouTube, any of my social media channels. I am very open and willing to accommodate those. Thanks for hanging out. I will see you next time. I'll probably go live either later this week, if not early next week, because I don't want to leave y'all hanging for too long. But thanks for hanging out. Bye-bye.